Assalamualaikum warahmatullahi wabarakatuh. This is part 3 of our lecture or discussion for the topic trespass to person. So in the previous parts, part 1 and part 2, I have covered trespass to person, which is assault, and then followed by battery in part 2. So now it's part 3. Actually, I want to have only 3 parts, but when I look at my slides, so there are still quite a number of slides to be completed. So there will be part 3, which is quite short, and followed by part 4. So part 3 is meant to discuss false imprisonment, okay, and then followed by another subtopic, defenses for trespass to person. So without any further ado, let's start with false imprisonment. Okay, before we go to the elements, so let's discuss about the definition, okay, of the term. Okay, here, all right, false imprisonment. So basically, it refers to infliction, okay, of bodily restraint. So that's the keyword. Okay, I put it in yellow font here, yellow color, right? Bodily restraint, which causes the confinement, okay, of the plaintiff within an area determined by the defendant, which is not expressly or impliedly authorized by law. So there are a few keywords here actually. Okay, basically we have the word restraint and then confinement, okay, and then within certain specific area. Of course, it is done by the defendant towards the plaintiff. And the last part actually it covers the justification, all right, which is not expressly or impliedly authorized by law. Okay, let's move further. Okay, the word, the term, okay, here the phrase false imprisonment. So if we have a closer look, actually, yeah, we can see two words here, all right. It is from the words, okay, false and imprisonment. So what's the meaning of the word false here? Basically, false here, it refers to wrongful, certain act which is wrongful in the eyes of law, all right. And what's the meaning of the word imprisonment here? Okay, imprisonment from the word prison, okay, but here this is a verb, all right. So imprisonment, it means restraining, okay, to restrain a person liberty, freedom, okay, to go to any place at any time he wills, meaning that here he is not allowed to go to the place that he wants to, okay, all right. And then another important consideration, all right, for me to mention here is about Article 5, okay, Clause 1 of our Malaysian Federal Constitution, or FC, that's the acronym or short form, okay. So under this particular article, all right, it is stated that no person, okay, shall be, so it's a very strong word here, shall be deprived of his personal liberty save in accordance with the law, right? So basically, this right, okay, this freedom is enjoyed by all citizens, okay, of Malaysia, okay. But then we have also the last part of the provision here, okay, save in accordance with the law. So there could be some exception here, right? But generally, okay, the rule is that all person, okay, everyone is guaranteed, okay, of their personal liberty. So that's why false imprisonment is not allowed, okay, because why? It goes against this personal liberty as guaranteed, okay, by federal constitution. Okay, let's move further. Okay, now we go, because now we have just now we have discussed, we have looked at the definition. Now we go to the elements, okay, like we did in the previous parts of our topic. We discussed all the elements. If you still remember, okay, assault have 3 elements, and battery also have 3 elements. And then similarly to this topic, false imprisonment, it also has 3 elements. Okay, so basically the one who alleged must prove, claimant or plaintiff. So plaintiff must prove the first one, okay, his or her personal liberty has been restrained. Remember the keyword here, restraint? And then next, the second element is the restraint, okay, so is connected to the first one. The restraint was intentional, okay, because why? Trespass to person is essentially intentional thoughts, all right? So it has to be intentional. There must be intention on the part of the defendant. And then the third one, okay, the restraint. Again, it's about restraint here. The restraint must be complete. Okay, we are going to discuss what's the meaning of the word complete here. So altogether, there are three elements, and all the three elements here must be fulfilled in order to prove a case of false imprisonment. Okay, the first element, okay, is about a restraint. Okay, personal liberty has been restrained. So let's have a look at the common law case here. The case is Walden and Home Office 1994. So it's about a person, okay, the plaintiff has been confined, okay, he has been placed in strip cell, okay, for overnight. What is strip cell here? Okay, strip cell is a cell without anything beyond a concrete bedding area, toilet and sink. Okay, prisoners in these conditions wear a smoke or tear-resistant gown. So basically, this is a specific cell which is called strip cell here. So what's the issue in this case? The issue was, okay, whether a lawful imprisonment, okay, may be rendered unlawful by reason only of the condition of the detention. Meaning here, the condition of the detention was not being fulfilled. Okay, whether it is still a lawful imprisonment or it trespasses the boundary and it amounts to unlawful imprisonment here. So the court held that, well, no. Okay, why? Because it started with lawful, then it is still lawful. It is still a lawful imprisonment. Okay, all right. And the remedies here, it is stated as damages, okay, assault, damages for assault and battery, but of course not the release of the prisoner. So meaning that here, if it is a case of false imprisonment, all right, the claimant, okay, the plaintiff can get damages, compensation for assault and battery, which is allowed for assault and battery, but of course, okay, it is not included of release of the prisoner. Okay, you can't be released, okay, based on the claim. Okay, I mean the plaintiff is allowed damages but not the release, okay, even though the case has been proved. Okay, the second element, okay, remember we have three elements. So the second element is, okay, the restraint was intentional. So it is the intention, okay, on the part of the defendant. Okay, so basically the restraint was a direct consequence of the defendant's act. Okay, direct and intentional is present, okay, throughout the act here. We have the case of Harnett and Bond, quite old. It is quite an old case here, 1925, in which the emphasis of this case is proof of intention was necessary in order to prove a case of false imprisonment. There must be intention. Okay, let's have a look at the facts here. So the plaintiff, he was an inmate, okay, at a licensed house for lunatics, okay. And then he was granted a month's leave, okay, but could be reconfined by Dr. Adam in that period. So she was given a leave, all right, here. Sorry, he was given a leave. So he went to the offices of the commissioners for lunacy and saw Dr. Bond, okay, who concluded that he was not fit to be at large, so he cannot be released or be free, right? Not to be fit, not fit to be at large here. So because of that, okay, he sent for a car to take him to Dr. Adam. So Dr. Bond arranged for a car, okay, to take a plaintiff right to Dr. Adam. Remember, Dr. Adam has the authority, okay, to reconfine plaintiff here. So, and then detain him pending the arrival of the car 3 hours later. So, Dr. Bond detained a plaintiff, right, while waiting for the car, all right? So, the court held that later the plaintiff brought the case again against Dr. Bond. So, the court held that, okay, Dr. Bond had no right to detain the plaintiff pending the arrival of Dr. Adams' car. And because of that, Dr. Bond was liable in damages for that illegal detention. So the period pending the car, okay, here, because at the first place, Dr. Bond has no right whatsoever, okay. The authority was given only to Dr. Adam. Okay, that's the case of Harnett and Bond. Okay, the third element for false imprisonment is that the restraint must be complete. Okay, what's the meaning of the word complete here? It means, okay, there's no reasonable means of escape. There's no way that plaintiff can escape here. All right, we have the leading case of Bird and Jules. Okay, we're going to discuss after this. And then another consideration is that knowledge of the plaintiff that he was restrained is immaterial. So it's not really, it doesn't really matter, okay, whether plaintiff knows he was being restrained or not. Maybe he only discovered it later, or maybe somebody told him, oh, you actually were under false imprisonment, for example. Okay, so it doesn't matter, it doesn't really matter, okay, here, all right. So we have the case of Mirroring and Murray, okay, here. All right, so for the case of Bird and Jones, very, very old case here, but it's a leading case, landmark case here. 1844, what happened? Defendant wrongfully, okay, enclosed part of the public footway on the bridge like this, okay. So there's a public part here, public footway, and then defendant wrongfully enclosed part of it, all right. And then seats were placed for spectators of regatta on the river. So basically that's the reason, okay. So he put certain seats here for them to watch a regatta on the river here, like this, okay. So the defendants refused to let the plaintiff to go forward in the enclosure. So meaning that here, plaintiff went inside the enclosure, okay, the enclosure, all right. So no, you cannot go forward. That's what the defendant said. But he was told that he could go back to the gate and get out of the enclosure if wish. Okay, you can't go. You can't move forward. Okay, but you can actually go back if you wish. Okay, all right. However, plaintiff can remain in the enclosure for half an hour, which is quite some time here. Okay, and later plaintiff sued defendants for false imprisonment because he was in the enclosure. Okay, he can't really, he couldn't really move forward. Okay, but remember, he could go back. He could move. I mean, he can just exit, okay, from the enclosure. The court held that there was no false imprisonment. Why? Because the restraint was not complete. There's an escape here. I mean, he can just go out, okay, and not necessarily that he cannot go out here. Okay, he wasn't really completely restrained. So again, the third element for this case, it shows to us the third element was not fulfilled. Okay, in the case of Mering and Graham White Aviation, okay, also another very classic case here, 1919. So the defendant, who was the defendant? Defendants actually here, they were policemen, okay, policemen. So they suspected plaintiff of stealing varnish from his employer. So because of that, plaintiff, okay, the suspect was asked to follow the police to the company's office. So plaintiff followed and waited in the waiting room while the policeman remained in the neighborhood. So meaning that here they just let him waited in the waiting room. Okay, so when the plaintiff brought the case to the court, okay, the defense by the policeman here, all right, he said that, well, actually, plaintiff was free to go where he wished. Okay, actually, even though I asked you to wait, but actually you are free to go. That's the defense by the police, the argument. But the court of appeal said, no, okay, you have to be liable. Defendant was liable because why? Okay, in that situation, once the plaintiff was under influence of police, okay, the plaintiff was no longer a free man. Meaning that here, he couldn't really go or just escape like that. Okay, here. So, and there was intention to restrain the liberty of the plaintiff. So basically, the contention, okay, the defense here failed. Okay, it wasn't accepted by the court. Okay. Otherwise, okay, it will defeat the purpose of police authority or police power. Okay, if you are being arrested or put under certain restraint, so you are no longer free. Okay, I mean you can't really simply go. And we have another case, Murray, I'm not sure how to pronounce it. Okay, Murray and Ministry of Defense here, 1988 case. In this case, Lord Griffith stated that, okay, this is the rule that we extract from the case. It is not an essential element that the victim should be aware of the facts of denial of liberty. FI is false imprisonment, meaning that here, knowledge is not an essential, okay? Meaning that here, it is possible for the plaintiff to be, to sue for false imprisonment, even though he was unconscious or he was being asleep or drunk, okay? So in theory, theoretically, okay, it is possible. Okay, all right, so we are done with part 3 of our lecture, which covers, we have covered just now, okay, the topic false imprisonment. So the part 4 we are going to continue part 4 later, okay, which covers defenses of trespass to person. So till then, thanks a lot, all right. So see you after this. Assalamualaikum warahmatullahi wabarakatuh.